like to welcome everybody to today's lecture. For those who may not know, the Balch column lists in our programs, classes, tours, and exhibits are in the back table there. Help yourself. Our back issues are also found on our website if you don't want paper, you want to read online. And I'd like to thank the Friends of the Thomas Balch Library for underwriting our classes and our lecture series. The water fountain is to the left out the back door there. Restrooms are straight back. If you have any kind of an electronic device, if you would please turn off or mute at this time. Please remember there is a virtual audience. The event is being recorded and will be published on the library's YouTube. The link will be made available to those who registered for the class and provided an email address. Those of you who are attending virtually may ask questions by posting in the chat box. It is my pleasure to welcome back our guest speaker, Wynne Saffer, a lifelong Loudoun resident. He will discuss researching with deeds using resources available at Thomas Balch Library and the clerk's office. Saffer has completed numerous local research projects, mapped the county by land ownership in 1860, and written several books about Loudoun's history, including Loudoun Votes, 1867 to 1966, a Civil War legacy, and Mount Zion Cemetery, Aldie, Virginia. Saffer is a recipient of the Thomas Balch Library's Loudoun History Award. Please join me in welcoming Wynne Saffer.
Oh, okay. I had a bottle of water in my refrigerator at home and I went off and left it.
Is one enough for you?
Oh, certainly. I also left my grocery store list laying on the counter, so I was writing that down earlier so I could still got enough memory to remember what I needed anyway. Well, welcome to Thomas Balch Library. I've taught this class several times before and I used a case study in it, so I'm going to repeat that, but I added a few slides this year. So first thing I'll do is tell you that I'm teaching about deeds, but there's a lot more about deeds that I'm not going to teach you. This is a book I had when I was in college, and it's called Real Estate, the Barnes and Noble's College Outline Series. That was the textbook I had in college. And then after I got out of college, I down at the courthouse looking up deeds, and here's the book I bought online called Title Examination in Virginia. So there's lots of information about deeds that are in there and lots of different types of deeds. But I'm primarily teaching from a historic or a genealogical base for the class. So you won't learn enough in this class to be a title examiner, but maybe you'll be able to learn enough to research deeds on your own if you're interested in either your property or some other property. All right. And then again, this is basically focused on Virginia. So these are Virginia. I'm sure many of these things apply to other East Coast states. But anyway, why do you research deeds? There's various reasons. All right, you're looking for your ancestor. Your ancestor owned real estate. There's excellent records on land. So if your ancestor owned real estate, they're much easier to find. If they didn't own property, they're much more difficult to find. But I'm going to mention a resource a little bit later that'll talk about maybe if your ancestor was a neighbor of somebody but didn't own the land, they were leasing it, they might show up in somebody else's deed. Okay, who were my ancestors' parents or brothers and sisters? Deeds will show relationships sometimes. Sometimes a deed will say that a person is from a given county. So I'll be from Frederick County, Maryland when I buy a piece of land in Loudoun County, Virginia. So sometimes the deeds will give you a clue to where the person came from. That's not always the case. Once in a while, people will move to this area and they'll buy a piece of property, but they've been here a couple of weeks. So they say, oh, Loudoun County, then rather than say where they came from. But deeds can tell you where they came from. And property can connect generations of people. So quite often people inherit property from their parent or their grandparent. So you'll find connections, other generations. So it allows you to do more genealogy. And also gives you the names of the wife. When you sell land, quite often a man may buy a piece of property, but when he sells the land, the wife has an interest in his property called a dower right. and she has to sign the deed when he sells it. Otherwise, she may come back and claim that dower right from the new owner. So they always make the wife usually sign when there's a sale of property. Who owned my property? A lot of people come into Balch Library researching their land. Joe was in here the other day looking at some of his land. So when people buy property, quite often they want to know who lived there previous to them, when was the house built, things like that. They're trying to figure out by doing the deed research. And where did someone live or a historical event occur? So sometimes deed research will help you pinpoint a location. I saw Joe had the book between Reb and Yank, Civil War references, and sometimes people are looking for where a Civil War action occurred. And it may mention the name of the property owner, so they can sometimes zero in on where this event took place by trying to locate the property through the deed research. So there's many ways or many reasons why people would research property. When you're dealing with deeds, there are several terms I want to define for you. Chain of title is the chronological record of ownership and references. All of these slides are on my handout that was in the table in the back. So if you get one of those, you'll have all the slides. Chain of title is not something you go down to the courthouse and find. Chain of title is something you create. If you were a title firm where you're doing a chain of title for a lender, they'll keep records in their offices of what they've researched on chains of title. But chains of title is just a series of property titles, but they're not connected at the courthouse. You don't find them. All you find is the individual deeds recorded. But when you're doing property research, you want to create a chain of title because you want to find one goes to another. I'll show you several examples of that today. The grantor is the person selling the property, and the grantee is the person receiving the property. In some courthouses, they have separate indexes for grantor and grantee. Loudoun does not. Loudoun uses the index that says to and from. So you can tell if it's to, you're the grantor. If it's from, then you're the grantee. But those terms are buyer and seller is what we would normally say today, but that's a legalistic term quite often used with deeds. Meets and bounds, a description of the property giving direction and distance from each point. I'm not going to go into that extensively today, but if you have meets and bounds, you can survey the property. But not every deed has a meets and bounds survey in it. There's no requirement. You have a description of the property, but you don't have to have a survey in it. Surveys quite often never happen if you have a relative. So if a father is giving a piece of land to his son or selling it to his brother, they rarely will have a survey recorded in the deed. They won't go to the expense. But if you're a stranger buying from someone, you want a survey because you want to know where your corners are, where your lines are. So most deeds have surveys in it, but not all of them by any means. Parts of a deed. I'm going to show you an example of a deed later, and I can point out the parts if we go through. But the first part of the deed is the caption. It has the date. So that's an important factor is the date. Grantor and grantee are listed in that. Then the consideration, when I extract information from a deed, I rarely list consideration. In the change of title I'm going to show you today, I don't have a column set up for consideration. Main reason I don't do it is because the value of the money over historical time changes. So it's not really meaningful from that standpoint. If you have other deeds from the same period, you can see comparable values to the property. But like it wouldn't be uncommon to sell a lot for $100. Okay, you couldn't go out there and buy a lot of land for $100 today. So you'd have to say, well, what is $100 worth in 1840? So that's why I don't usually extract the consideration. Now, one thing about consideration is if there's structures on the property. You buy a piece of land that has a house on it, it's going to be more expensive. And usually sometimes by the deeds, you can tell if a house has been built or not built. So if you're writing down the consideration, you may be able to discover when the house is built by seeing the increase in the price as property sold. A granting clause, intention of the owner to convey the property. Description, and this is where I was talking about earlier. I wrote down several descriptions, but in all cases, I'm talking about the same property. Lot number 40 in Goose Creek Farms, or Wildman Farm in Mercer District, or same as conveyed by deed book, or bounded by Lime Kill Road on south, or meets and bounds. So you can have various descriptions of the property, and as you go through trying to go from one deed to the other, the description won't always be the same. It may be, these all relate to the same property, these various descriptions I have, but you might not be able to tell that from reading it. So usually when you're looking for a chain of title, you're actually going from one deed to another, and you're comparing the descriptions to see if it's the same property. Because one of the things you'll find if you actually do some title research is that some people own multiple pieces of land. There are people in historical and even today that go out there and they buy multiple pieces of property. Well-to-do people back in the day would go down to the courthouse when they auctioned off a piece of land and they would buy it as a speculative investment. And so as you go through the chain of title and you hit, let's say, William Nichols from Western Loudoun, well, Nichols probably owns a dozen pieces of land. So, but you're only interested in a specific piece of property. Well, does that deed you went to, is that the same property that William Nichols bought in the previous deed you looked at? So that you have to look at the descriptions to make sure that what you're reading is the same. If you just deal with the grantor and the grantee, which is normally the way you're following the deed is going from the previous owner, you can locate a deed for that person, but it might not be for the same property that you're interested in. So the description is very important to look at. Derivation clause, grantor source of title. The process of researching deeds is typically meant to go backward. So you start with the owner today and you work backward. But property, you can research it both forward and backward in time. But if you're going backward in time, when you read this derivation clause, it should tell you what the previous ownership record is. So let's say I'm looking at a deed and it says the previous record was 13V, page 196. All right. So then you can go to that book and you'll look that deed up, and that's the next deed. But back, you're going to find as you get back in time that that's a very weakly performed information. They don't always put the source of title in deeds back in the 1860s, 1840s, 1850s. You'll find gaps in that. Early on, it seems like they always had that in there. And today you'll almost always have it. But there's a point there in the middle part of history there that they just didn't bother to write it down. And what I even hate is worse is when the lawyer who's filling out the deed is a little lax and writes the wrong source down. I've seen that on occasion. It'll say 13V when it turns out it was actually 13U. So that'll throw you off sometimes when you go look at that reference and it's like, well, wait a minute, this isn't even the same people. So sometimes they'll have just a mistake by the attorney and they wrote down the wrong reference when they were writing it down. So you have to be careful about that, but that's very helpful. Signatures, the signature of the grantor, as I said earlier about the men and women, the husband may have bought the property, but when he sells it, both he and his wife are supposed to sign it, all right? And if it's multiple ownership, if the property was received through inheritance, there may be 5 children, they each had 1/5 ownership. All 5 of them would have to sign the deed. And sometimes you'll see multiple deeds. The purchaser will buy the interest from each of the 5 owners. So there may be 3 deeds signed by the 5 children. All right, they'll have one deed with two of the children's names on it, another with two, and maybe one with a third or the fifth. So, and that particularly happens when these people disperse. When you have heirs that have moved west to Tennessee or Kentucky or someplace, they'll still have to get them to sign the deed, but it takes them a while to send the piece of paper out there and have them sign it. And then you'll have some notary out there that'll also have his entrance on the deed saying that he's notarized that person's signature. There's multiple types of deeds. The letters I'm using are in the deed index. So B and S is a bargain and sale. That's a typical deed where you're transferring property. Then you have leases. Now, there is a weakness in that early on, a lot of leases weren't recorded. So in Piedmont Manor, which is the northern part of the county around the Lovettsville area, that was mainly leased land up until about 1800. And most of that, a lot of them are not recorded. And then down in the southern part of, I've worked in Fauquier County where Leeds Manor is, there's a lot of leases that are not recorded down there. Just because a document, a bargain sale or lease is entered, it doesn't require recording to make it a legal document. If you sell a piece of property to somebody and you have a deed, that's a legal sale. The recording is the protection of the buyer, though. Because if the buyer doesn't have the document recorded, that seller might unscrupulously sell that same piece of land to somebody else. So that recording creates a protection for the buyer of the property, that his deed has been recorded, and then he's protected because when they go to sell the land, they'll look up in the index to see if there's a previous sale of that property, so they'll find that. So recording is important, but it doesn't make it legal just because it's recorded. It has to be contain certain contents in order to make it a legal document. Let me go back one here. So back to the consideration. Typically, you have to have at least, there's a term they use, $10 or $10 more or less. You have to have a dollar value in order to make it a legal transfer. One of the expressions when it's a deed of gift, they use the term for natural love and affection. But there has to be some value in order to make it a binding contract when you're selling land. L&R is a lease and release. That's basically the same as a bargain and sale. Early on, and you'll see two documents recorded. You'll see the lease and you'll see the release, and then we recorded back to back. That occurs in Loudoun in the 1700s. You don't see that currently or later on, but that was a procedure done. When I first ran across it, I didn't know what it was, and I asked one of the title examiners, and he explained it to me. So lease and release basically is a lease and then a sale right behind it. So that is a transfer of property. A deed of trust is when money is loaned on a property. So typically we call it a mortgage, but you'll see trust in the deed index. When I go through the chain of title, I rarely list those trusts. When you borrow money on property, it's a lien against the property and it's recorded in the book. Now, they used to have what they call a marginal release, where the clerk would come in when the mortgage was paid off, and he'd make a little notation on the edge of the deed in the record book. Well, now they don't do that anymore. Now they record what they call a deed of release. So they have a deed of release today, but back in the day, they used to just go into the deed book and the clerk would actually write down this trust was released on such and such days, meaning that it was paid up. From a historical standpoint, I don't usually find those of much value to look at. I have occasionally used deeds of trust to find a deed that I couldn't find otherwise. But for the most part, if you borrowed money to finance your purchase of the property and the deed of trust was recorded, if this is in the 1860s, it's been paid off a long time ago. You're not gonna worry about looking to see if it was paid off or not. And if it wasn't paid off, there'd be a deed of foreclosure where they foreclosed on the property. So you're gonna have a change, so you're probably not looking for the deeds of trust. Now, when you're a title examiner, those deeds of trust are very important because you want to make sure, is there money loaned on the property and has it been paid off? Or is the new buyer going to have to assume the trust that's still existing, or is the seller going to have to pay that trust off before they can complete the transaction? So from a current transaction and the title examiners, that's very important, but from a historical perspective, deeds of trust don't really tell you a lot. And I've seen quite often sometimes where there's multiple deeds of trust. So somebody will borrow money on their property and then they'll pay it off. And then they'll go borrow some more money and then they'll pay it off because the property is of value. It's a form of collateral that you can put up to borrow money on. And historically, people needed funds, particularly farmers, to make ends meet, so that if they had paid off their mortgage, they might have to get a new mortgage to cover expenses in a subsequent year. So you see multiple trusts over time. So I tend not to extract those. Sometimes wealthy people, one of the things back in the 1800s, there weren't that many banks around to provide lending. And so most lending was done by individuals. So wealthy people like Elizabeth Carter at Oatlands or William Nichols, who I mentioned, you'll see them listed in the book for trust after trust after trust, because they're loaning money out to people to buy a property with. So that was how they invested their excess capital, was in mortgages. And it's secure. If you know the property is worth something, you're not going to lose your money. So, and then the last is the deed of division. Division of property, and it's usually to heirs. I find those very helpful because they usually have a plat. I haven't talked to you about plats yet, but plat is actually a drawing of the property. So it tells you what the shape of the property is. You see the lines in that. And a deed of division is usually, again, from heirs. So you're dealing with multiple people. So if you're trying to do genealogy, a deed of division is going to list all the brothers and sisters who inherited from the father or mother. Other types of transactions. I own a piece of property in Loudoun County. Well, actually, I own half of an interest in a piece of property in Loudoun County, but there's no deed for my ownership because I inherited the land that I live on. So I have a 1/2 ownership that I inherited, 1/3 interest in 1988 when my father passed away. And then in 2002, when my mother passed away, I increased from 1/3 ownership to 1/2 ownership. I still have to deal with this brother of mine anyway. But anyway, dower and curtsy, I mentioned dower earlier. The dower is a woman's right and curtsy is a man's right. So the man has an interest in the woman's property, and the woman has an interest in her husband's property. But inheritance is getting property by will. And when I'm researching deeds, I'm usually going to the deed index, going from one deed to the other. And if it has the derivation clause I was talking about, if you're going backwards, you can look at that derivation clause and find the previous instrument that you're looking for. But when you hit the will, going back, the derivation clause may mention to you that it's a will, may tell you it's a will. So you know that it's a will you're looking for. But it won't be in the deed index because there's a separate index for wills. So you have to realize that the property was received by inheritance before you start looking in the wills. So that's, again, you're kind of working with the deeds, but all of a sudden now it's inheritance. And it's very common that property is transferred by inheritance. That over the history of a chain of title, it's rarely you ever go through and there's not a will in there somewhere. That property quite often gets transferred by wills. Marriage. Now this is the one that always throws me, as marriages. When I'm out doing research in Virginia back in 1800s, ladies in the audience probably appreciate this, is, or maybe they won't, maybe they don't appreciate it. Anyway, that when you married somebody, their property, the woman's property became the man's. So the tax man says that the man owns it, but there's no deed for that guy anywhere. Because the property belonged to his wife. And I never think about that till I get stuck. You know, I'm working back on a chain, it's like, where'd this guy get this property from? There's no index in the deed for him to receive a piece of land. And there's no will for anybody, even if I know who his father is, there's no index in the will book for his father, or if it does, it doesn't say anything about any property in the will. How did he get it? Then I think, oh, wait a minute, he got it from his wife. So that happens occasionally. It doesn't happen a heck of a lot of times, but one of the things that I learned back early on was that when a man dies and he's got a daughter, he very well would leave her a piece of property. But if she was either already married or he was worried that she might marry some drunkard or ne'er-do-well, that he would put in his will that I leave this property in trust to my attorney for my daughter. So if they leave the land in trust to the daughter, then by marriage, the husband doesn't get it. But if she owns it outright, once she marries him, he's got it. And he can gamble away the property, you know, and lose his property that he got from his wife. So quite often husbands or fathers were very concerned that their daughters would marry the wrong type of guy and the money and the property would go away. So it's very common for wealthy people that they would put the land they left to their trust. Chancery suits are great because they give you lots of information. Quite often, court suits seeking sale or division of property. So I said deed of division earlier. Usually if you find a deed of division in the index, there probably is a chancery suit related to it. And you can look through the chancery index and it'll tell you a lot more about it, about, you know, when the property came into the family and who the various heirs are. And you'll learn a lot about it from that. And tax sale, we still have that today. There are people out there that can't pay their taxes and the government sells the property away from them. So back in the early days, the sheriff was doing the sales. The sheriff doesn't get involved in that stuff anymore, but historically the sheriff would handle the tax sales. But you can have property change. So you're looking from grantor A sells to grantee B, and then B, who becomes the owner now, is the grantor, and he sells it to purchaser C. So you're going from one name to the other when you're working backwards, but all of a sudden, you're not looking for the right name in the index because the person selling it is the sheriff rather than the name of the person that owned the property. So that's one thing that'll throw you sometime. The same can be for foreclosure, that the name of the person selling may not be the previous owner. It may be the attorney's name, who's a trustee that was appointed under the deed of trust. Now the good part, sources. Okay, this is all on microfilm. Any of y'all use microfilm? All right. One of the new staff up there the other day asked me about, she was using a printed source for deeds. And she said, well, do we have the actual deed records before someone else? And I said, yeah, that's on microfilm. That's his deed index. I think there are 4 reels of film that cover this time frame here. After 1878, the library doesn't have an index of the deeds. All right. But The archives section of the courthouse has a website, and you go on their website and they actually have the deed indexes scanned. And you can look at the index online. I don't think it comes up current. I think you can only get to like 2000 or something like that, but they do have the indexes online that you can look at. But you can't look at the deeds here because we don't have microfilm of those deeds, and the deeds are not scanned online. Now, if you're a title examiner, you pay the clerk annually for electronic access to his deed records, and you can go online at your home 24/7 and look up the deeds. But if you're not paying, and I think it costs something like $600 every 6 months or something, so you're paying like $100 a month to get access. And I think they have a setup fee they charge you too. So I don't think too many private citizens have it, but people like real estate companies and title examiners quite often have electronic access to the court records. But Balch Library doesn't pay for us to get that, so we can't look at the. Hey, all right. Then there's deed books. In Loudoun, they lettered them initially. So you had deed book A in 1757. And then they went A, B, C, they get to the end of the alphabet. And then it's AA, which eventually would become 2A and 2B and 2C. And I think they went up till about 13, I think, or maybe I'm just trying to remember from memory, but what we have a microfilm here takes you to, takes you to 7T, which is 1901. But at some point in time, they counted up all the books they had and they started using a number. So today, I shouldn't say today. So eventually they started numbering the books instead of the letters. They stopped doing that repetitive letter thing. And they just started, I think they were 318 or whatever. Well, today they no longer have books. Books are ancient history. Now they just have documents online. Everything's electronic now, so there's no deed book. The deed book was actually a book with a number on the spine, and then the pages are each numbered. And so the reference you have was like book A, page 1, 2, 3. But now they have what they call an instrument number. The other next thing is wills, will index. There's one of those as well. I said, you look in the deed index, but all of a sudden it's inherited, so you have to look in the will index. And the will books that we have on microfilm here go from A to 2S. And then 3A to 3C. I don't know, I think for some reason when the library bought them, they had a gap. So between 2S and 3A, they don't have the will books there. And then the land tax records is very important. Now, not too many people use these. And there's a good reason for that. The things on microfilm are very difficult to read. Some of them are actually illegible. But we have the microfilm here. I don't think the courthouse even has these things. They've sent these things to Richmond and they're stored at the Library of Virginia. So you can't even look at them down at the courthouse. All you can do is look at them on microfilm here. But the actual records are in Richmond. But even if you went to the Library of Virginia, they'd hand you the microfilm if you wanted to look at them. And you'd say, well, I can't read the microfilm. How about let me look at the book to see if I can read it? So they have the original books there, but they want you to use the microfilm. Kind of like using the newspapers here. They have a lot of the original newspapers, but they want us to use the microfilm because if you're thumbing through the newspapers, you're going to wear them out. And that's the same problem with the tax records. But I always say, the tax man cometh, he knows who owns the land. If the tax man sent you a bill for a piece of property and you didn't own it, would you pay it? No. So if he sent the tax bill out to somebody and he sold the land, he'd send it back to him and say, I don't own this anymore. I sold this. I don't own that piece of property anymore. All right.
So wait, what's online?
What's online?
Is the microfilm online?
The deed indexes are online
Okay.
that you can examine at the Circuit Court Clerk's Archive website, has the deed indexes on it. The deed books are not online. The will indexes, I don't think he has those online, but he may. And the land tax records are not online. So yeah, the main thing you can do is you can look at the deed indexes, and they have years past 1878, so you could actually look those up. But the problem I have with that is when you look at something in the index and you think you have the right transaction, you can't determine right away because you don't have access to the deed. You have to go down to the courthouse, look the deed up. So when you get down there and you say, wait a minute, I wrote this down, it's just not the right one. It's not for the piece of property I'm looking for. So that's the difficulty of just having access to the index and not having access to the deeds themselves. So you need to read the deed to make sure you have the right deed, because as I say, buyers buy multiple pieces of property, you know it's the same guy you were looking for, so he sold a piece of property, but it wasn't the piece that he owned that you were researching. So that's where you really need the deeds to give the answer. So it's the indexes are not that helpful unless you have the deed to look at to make sure. Now I'm going to get back to this book here in a minute because that's on my very next slide. These are other resources that are very helpful. I like to use Mary Alice Wirtz's marriage book. Because if I'm looking for somebody who owns a piece of property, a man, and I can't find out, that I found no deed for him, I'll look him up and see who he married and maybe figure out who his wife was and figure out where he got the land from. The will index, Louisa Hudson, I will say I use Mary Alice Wirtz's index. There's another, can you tell me what the name of that is?
No,
Shoot.
put me on the spot, sorry.
There's another very good index of marriages for Loudoun County that covers the same period by Voigt, B-O-G-T. Has an index as well, but I don't use his. I always use Mary Alice's. Louisa Hutchins did a book on wills, and in it she's extracted names. But that's helpful if you're trying to find a will. The person had the property, now you're trying to figure out who got it, and you haven't looked at the will index, but you could look in her index and it lists all the heirs. So all the heirs that were listed in the will, she'll have them extracted. Extracts of deeds, Ruth and Sam Sporatio did early deeds for 1757 to 1796, 20 volumes. This fellow Wynne Saffer here did land tax maps. I did 3 of those from 1860. What I did was basically I went through the people listed in the tax records and tried to map the property. And I probably got about 85% coverage. So I didn't do anybody with 10 acres or less, which included all town lots. And if I couldn't find a survey, I couldn't map it. If it just said the farm on Ryan Road, that wouldn't have done me any good because I couldn't figure out where the boundaries were. So that's available for 1860. So if you're trying to find whether somebody owned a piece of land in 1860 and where it is, you can use those map books. There's one for each of the 3 assessors districts. And then lastly on here is my good friend, Pat Duncan. How many books does Pat have in the library?
A lot.
A lot. She's probably got about 30 or 40 books in the library that she's extracted information. This is the first volume of the deed so I mentioned that there's, I think, about 10 of these that she did, and they go up to 1846 for V. I had some young college students here doing research, and I told them that use this. Look it up in here. She has a nice index in the back. And so if your person that you're trying to find didn't own a piece of property, but they were a witness to a deed, or they were an adjacent property owner or leasee who didn't get recorded, they'll be in her index. They won't be in the courthouse index, but they'll be in Pat's index. So Pat's is very much helpful for that. But the other thing is she extracts deeds and gives you a basic summary of what's going on. And it's printed, it's not handwritten as all of these original documents are. So if you're not used to reading hand script, I find this is very helpful to use. I quite often, when I'm looking things up, I'll look it up in the index and then I'll go to these books to decide whether I want to actually roll the microfilm up and look at the original. If I've got the one I'm interested in or pretty sure it is, I'll definitely look at the original, but I use Pat in the meantime to cut down on the work. So if the guy had 10 deeds of property they were selling, I'd look at her description of that property in this book before I bother to roll the deeds up, because it takes a lot longer to use the microfilm. And again, those deed books, there's like maybe 2 or 3 on one roll of film. So if the deed books are pretty far apart, you have an issue with them. I mentioned earlier about the date. I was thinking one issue I had one time. I had 3 deeds that all had the exact same date, where this one individual sold 3 pieces of property from, they were all adjoining, to 3 different people. But they were recorded in 3 different deed books. So how the heck did that happen? 3 deed books when they're all recorded at the same, or written at the same time, sold to 3 neighbors? Why did it take 3 deed books? Well, back in the early history, quite often they didn't have people to borrow money from, so it was self-finance. The owner was selling the property and they were paying in installments. They paid installments, so they sold the property for $300 and they had to pay $100 every year for 3 years. Well, once they paid the 3rd payment, the owner actually went down and recorded the deed at the courthouse. They didn't bother to record the deed till the deed was paid off. So that's why those 3 deeds were in 3 different deed books. It took time for those purchasers to pay them off. And so even though the date entered on the deed was identical in all 3, the recording was done at different times because of when the payment finally occurred. Little quirky things. Now this is where I've added this. This is my personalization. Any of y'all recognize that man? Oh, that's my father. I don't know the dog's name. And his picture was taken in front of the house. This was in the 1930s, I think. He was born in 1909. I think he's in his 20s in this photo here. This is a chain of title for the property that he's standing in front of. And they called it Cottage Farm. In 1858, Elias Ayers trustee sold it to William Thornton Saffer. So that was my great-grandfather. And the next 2 generations of my family, my grandfather and my father, were both born at that house in that picture there. But by 1975, Johnny Appleseed, which is my cousin, Johnny Appleseed was owned by my first cousin here. He sold it to Washington Forest Foundation because he couldn't pay the mortgage on his property. So he was sold down the river, as we say. So anyway, this piece of property was in my family, immediate family, from 1858 to 1975. It's not owned by us today. I'm gonna go to the next slide. Oh, I did want to point out one thing over here while I got the slide up here. We think the house was built when Robert Armstead owned it. Robert Armstead bought it in 1804. We think, or excuse me, 1795, Robert Armstead. He bought some additional land. So we think the house was built when Armstead owned it about 1798. So the house is fairly old. But I spent more time in it, not when my family was there, but when this friend of mine, William Pollard, and his wife bought the property in 1986. I've been in the house longer, more times when Bill lived there than when my family lived there. My uncle actually lived there when I was in high school. But I would rarely go over there, and so I spent more time at the house when Bill and I was friends with Bill. So, but today, it's owned by Wat Pa Natachart Buddhist Temple. So it's a Buddhist temple today. I like to tell people that all the Saffers have been Buddhist for a long time, but that's not really true. But the house is a Buddhist temple today. And I want to go back here. I'm going to point out this more in my example I'm giving you earlier, but you see how the acreage starts? So here's a land grant from Lord Fairfax. That's Northern Neck land grant from 1740. That's not at the deed, that's not a deed, that's a land grant. Excuse me. The deeds start in 1772 is the first deed, but it's for the exact same property. But you see how the acreage jumps around? When you follow property, that's part of the description is the number of acres that it is. And so you're hopefully the same acreage is going to go from year to year, and that's how you tell you're on the right chain. You're on the right property. But people sell off parts of land, or they buy two pieces and then sell them together. So acreage jumps around. I'm not exactly sure what this is here from 1858 to 1936. That's when my grandfather died. See, it increased by 4 acres. I don't know where that 4 acres came from. Maybe it was just a variation on the tax records. I don't know. I don't know if there's another 4 acres somewhere. I don't think there was another 4 acres. I think the tax record guy just changed it to 350 for some reason. They might have had some kind of survey or something. But anyway, so that's one of the things you're looking for when you're chasing title. Well, when you get down to here, you see the 10 acres? They sold off all the real estate except for the house. The house is on 10 acres. That's a 10-acre parcel today, and you can see it as the next page, it's constantly staying at 10 because that's the same parcel throughout. And this is a picture of the house when Bill Pollard had it restored. Looks very much nicer today. It's 3 sections, stone on this end, brick here, and another brick piece here. And he whitewashed it so it all looks like one building instead of 3 different pieces of property. I thought he did a nice job fixing it up. It doesn't look quite the same now that the Buddhists have taken over, but I don't have a picture for them, so I can't.
So where is this?
This is the Skinner house next to Mount Zion Church, where Mosby took his wounded after the fight at Mount Zion Church. You've been there, I know.
Numerous times.
All right, this is where the sample starts. How am I doing on time? Okay. He's nodding to me over here. Anyway, this is my case study for you. I really like this. I told Laura I put this additional signage in to show you another chain of title. But when I was talking about the numbers changing, boy, I got some odd numbers here, don't I? It's jumping all over the map there. All right, starts with a land grant. All of the property in Loudoun was granted by Thomas Lord Fairfax, 6th Lord Fairfax. And he granted in 1727, 11,375 acres, just a nice small piece of property. And what do you know? There's a dispute. There's a dispute by the family as to who's entitled to this land. So when old Robert Carter Jr. dies, George is one of his sons, and John Tasker Carter is one of his sons. But you see, there's another 5,000 acres there. It went from 11,000 to only about 5,600. What happened to the rest of the land? Well, one of Robert Carter's other sons figured he was entitled to it. Figured he was entitled to some of it. So prior to here, it disappeared. But the property I'm interested in is part of this 5,000 acres, so it wasn't part of that other 5,000, so we don't follow that. We leave that behind, let's divide it out. 5,000 in the will from 1804 of Robert Counselor Carter went to his sons George and John Pastor Carter. Anybody ever heard of George Carter? Where did he live? Oh, that's right, that's the guy from Oakland. Well, he's gonna sell a piece of land in 1805 to Edward Coe. I got a copy in your handout of the deed to Coe. It's gonna come up here in a second, but I just want to say that this is the property I'm following is part of this 500 acres that Edward Coe buys from George Carter in 1805. So it started out part of this original land grant, and now it's going to leave the Carter family in 1805. Goodbye to the Carters. And we're going to the Coes. And y'all ever heard of Coes? You don't know Robert Coe? He's buried at Mount Zion. He's the guy right down here. He owns the mill up at North Fork. You don't know where North Fork is? Heard of North Fork, huh? All right, I'm jumping ahead on you. Anyway, so Edward Coe buys some more land. He buys 81 acres from George Nixon's executors, and he buys 241 acres from Moses Dillon. So now we've got 1, 2, 3 purchases. Oh, 4. Here, William Leakey sells him 80 acres. See, that's what these people do. They keep buying land and lumping it together. So now when you're trying to follow the deed, which one of these 4 pieces of property did it come out of? You know, that's what you don't know. If he sold some land, he ended up selling 8 3/4 acres to William Leakey. I'm assuming it's not part of the land he just bought from William Leakey, but he ends up a year later selling him 8 3/4 acres back. Then in 1815, he dies. Oh, Edward dies, and he recorded in a will book, Loudon Will Book L-116, his will. His will is very unique. I've never seen another one like it. See these 122 acres? He actually had a surveyor go out and survey the property before he died and divided it amongst his children. He created the division of his own. Usually they wait till they die, and then the court appoints 3 commissioners to divide his property in the chancery suit. But Edward didn't want to do that. He wanted to divide his property into lots based upon his own decisions as to where those children's property was to be, and he did it. So in his will, it actually lists the metes and bounds for every one of these pieces of land. And these are his people that he left to, the sons and a couple of granddaughters. And then he had a mill lot. He had a mill, and he left that in trust, right? And if you add all these 122s up in that 42.75, it should come pretty close to these 4 numbers less this one. Anybody can do that in their head real quick?
840.
You're probably close. I have to laugh because I teach kids classes at Mount Zion, and they can't figure out. I give them the years and they can't even figure out the number by subtracting one year from another. It's like they have to pull out the phone to figure out what the answer is. Or a calculator or something like that. Anyway,
So how early did he do this before he died?
I don't know exactly when the year 1815 is the year his will was recorded. So, but he had actually bothered to have this surveyed, and it's all listed in his will for every piece. Then what happens? This happens when they divide property all the time. They start selling back and forth to each other. Some of the Cove children die. All right, Edward M. Coe's et al. Sold to Robert Coe. Edward Coe sold to Coe's heirs. Robert Coe sold to Licky. They're selling people back and forth, and you can see there's little pieces of land. It's all over the place. All right, it's not going to make it easy for you. That's why I like this example. It shows you that it can get very complex or convoluted. It's very difficult sometimes to follow a chain of property. Well, I'm going to go to the next guy. The guy that starts to put it back together is a fellow by the name of Robert Bentley. And this is 1835, 36, and 39. Robert Bentley makes 3 purchases, 168, 132, and 121.5. Well, that's 300. So that's 421.5. Mr. Bentley acquires. He hasn't quite got as much as Edward Coe bought from George Carter, but he's got most of it. All right. He's ended up purchasing most of that original 525 acres. The Coes have retained some of it, but Bentley has brought some of the land back together. So all these kids are divided in the will, and now somebody else has come back in and tried to accumulate some land together. And then he ends up selling 22 of that acre. So he has about 400 acres in 1850. Robert Bentley does. Robert Bentley, when I did those 3 map books from 1860, he's the only person in Loudoun County who owns land in every one of those 3 districts. And you all know where Rokeby is? In 1860, Robert Bentley owns Rokeby. All right. He also owns Lansdowne. You ever heard of Lansdowne? He owns a big tract of land down there. All right. Lansdowne is in the Eastern District. That's Thomas Wren's district. Rokeby is in George Taverner's district, and this is in George Taverner's district. This property is, but he also owns some land in George Fox's district. He's the only person in 1860 who owns land in all 3 districts in Loudoun County. I thought that was kind of interesting. But that tells you one thing, that he's got money. All right, we'll go to the next slide. There's Robert Bentley is now selling in 1872, 400 acres to Ann S. Wildman, his daughter. So now we know that Robert Bentley is the father of Ann S. Wildman. And then some other people start selling land to the Wildmans. John Wildman's good. I guess he's the husband of Ann. All right. He buys 3 properties there and 3 more. And then Richard Tibbs sells him 20. See, this says it's from the Catherine Coe division. This is from the Catherine. So he's buying adjoining land to his 400 acres that Robert Bentley sold to his daughter. He even have 1 acre being sold to Ann Wildman here by John W. Burke. That was from Peter Steptoe for M140. Peter Steptoe was a pretty black man, but I don't think that's very important to the story. Anyway, now Ann Wildman in will leaves her 400 acres to her 4 children. Well, if you add up all this stuff, it's about 200 acres. So now it's up to 600. And Robert B. Wildman et al., that's all of the heirs of Ann, are selling it to Catherine L. Wildman. But then she buys 92 more acres from Howard and Ella Keyes. And now she has 692 acres. Now, I don't know if Christine Wildman is the same person as Catherine, but I think it's probably not. I think she's probably the child of this woman, or could be a sister, younger sister. Anyway, she ends up selling it to the Epps, Mary Jo Epps. And Mary Jo, who's the wife of Frank, sells Frank the property. So now we got 692 acres. So we started out with 525. Now we're down to 692. Now the numbers have jumped all over the place. And now the purchasers of the 692 are Robert and Barbara Hill, and it's known as the Wildman Farm. And what do? Well, they subdivide that piece of land, they start selling off lots. That's what people do today, don't they? All these developers, except it's, what is it, the Toll Brothers or somebody like that, that sell all this land. So they end up selling lots. I could not find in the deed book the subdivision plat for that 692 acres. I think it's there. I think somebody told me it was there. But I needed to look in the plat book and I didn't. But it's not in the deed books, but the plat, I think, was recorded in the plat books. There are plat books as well at the courthouse. But anyway, they sell it off, lot 40. Lot 40 is 10.5 acres. And this Webb bought it. And Webb sold it to Jones. Jones sold it to Myers. And Myers sold it to Zvi and Rena Glassman. And that's why I picked this lot. Because the Glassmans were friends of mine. They live out of Goose Creek Estates, or Goose Creek Farms. And they own lot number 40. I think they moved away. I think one of them, I think either the wife or the husband died, or maybe both of them died anyway. Their son's in the Dominican Republic, but I don't think that's very important to the story. But anyway, now I'm going to show you some of the information you'll see as you research this chain of title, as you try to find this. Here's the original deed to Edmund Cove. It's in 1805. And there's the plat in the deed book of the property. See, there's Goose Creek right there, and here's North Fork going up this way. North Fork of Goose Creek. See, I told you the Coves lived up in North Fork. Or at least that's where Cove's Mill was at North Fork. And y'all know this area of the county? You ever heard of Limekill Road? Oh, Limekill Road runs right along there. See that? That's Limekill Road going right down. This is on the north side of Goose Creek. Oakland's, the village of Oakland's is right in there somewhere. All right. So this is Goose Creek. Down where Limekill Road is, and these are the survey calls in the deed. If you actually could plat these out, you could do that. This is just one line right here that connects this point to that point. All right, 525 acres. And that Goose Creek Farms is in there somewhere. All right, this was from the assessments. This is online. I printed this off the computer. And there's my friends, the Glassmans. They own 10.10 acres, it says. I don't know why they don't have 10.50. Maybe there was a road they put in there, they gave them less property. Either that or the Z was trying to cheat the tax man, I don't know. Anyway, see this right here? 846-1174. Right there. That's the book and the page number that they obtained the property. Oh, it was 10.10 there. Yeah, I don't know why I went from 10.5 to 10.10. I didn't notice that much, but anyway. Maybe it was the road that caused that, because there's roads going into that subdivision. And that was in 1984 that I printed this off. So that's when they acquired this property. I haven't determined what's happened to the property now, but they had it in 1984. That's where it is. There's Goose Creek. Said Oakland is all somewhere. No, it's gotta be up here, actually, because the loop in the airport crosses. Right. 15's gotta be there, right? So there's, you come in here and you go up and down, there's where the property is. Again, I printed this off the website. This is off the county's mapping system. All right. You don't need this to research the title, but I just wanted to show you visually where this property is and that you can see it. Here's the same, I just zoomed in on a parcel there, I showed you the shape of it. And that I found in the deed book, there's a deed reference. And if you go back and look at the chain of title, you'll see this deed reference is in there. That's, I think, when the Youngs acquired it. Or maybe it's the first, maybe that's when the first one they sold, when they first sold the lot 40. It has the number on there and it's 10.5 acres, that's lot 40. I didn't put this in your slides because I'm not sure it's still valid today. This is off the county's, the courthouse's assessments or deed system, all right? So these are, when you go to the courthouse to look stuff up today, they have you use a computer. You can go over and use the books. They have the index books there and they have the deed books there. As I say, there's no longer deed books, it's now all online. But if you're trying to research from the current ownership backwards, you're gonna have to use the computer. And this was the original screen. I'm not sure that's the same anymore. You can see what this 2011 is when I printed this out. And then I updated these other slides to actually have a color screen now. I'm not even sure this is the same, but they keep changing these computer things, so this may be a different screen now than what it actually is when I did these copies, but they had the county logo on there. So this was, you can search by last name and organization, first name. And you can put a range of dates in here as to when you want to look. So you can actually use the computer to search for stuff. And even that early stuff is on the computer. There's another screen here. This was, you can search by book and page number. So you could actually go in and, but again, you'd have to be at the courthouse to do this. Unless you paid that $100 a month to access court records off your home computer. So if it feels like something you might want to do, you know, you can give Gary Clemens in the county a little bit of money and they'll let you look at their records. All right. And then this is another search screen. Now this I did. You probably can't do this. This is a deed mapper software. And this was Norman Fork, Edward Cove to Robert Cove, 97.5 acres. Which is where, right there. That's this piece right here. That's Robert Cove. That's where the mill is. I think, where was the mill up here? Anyway. That will from 1815 for Edward Cove that divided it. I put those survey calls in a software program. And if you look at this piece down here at the bottom, that's that original 525 acres that he got from from Robert Carter. So this is where the original land is, all down here. And that's where that Goose Creek Estate is in this. I think that may be the stream here. So these two pieces are probably on the other side of North Fork. Now, that's a stream there. Can you see that that's broken? You see it's got spots in it. That's what the software does to what they call a close. Do the plat, the stream, if they don't do a survey down the stream, you just, it automatically creates a broken line between the ending points. So you put in the points and then it just says the stream is here. The stream might be wandering all over the place. But it connects these 2 points. So when you see that broken line, it means it's an unknown line as far as the software is concerned. But anyway, I made this up when I did that to just kind of see what it looked like. So these are all the descriptions, this is platting all the descriptions. So this is a software, as I said, you probably wouldn't have access to. I don't have access to it now because my old computer died and it has my software on it, so. Now, this is a deed from Orr to Young in 1958. That's again on that list. This is the 692 acres. Right there, certain tract of land contains 692 acres. So here's the description. Here's the caption up here. Says the date and who the sellers or the grantor and the grantee is. Here's the consideration, $10 and other good and valuable consideration. How much did he pay for it?
You know,
No, they don't tell you, do they? Now, there's probably a deed of trust right after this, and the trusts are required to state under law how much the tax on that is. I mean, how much the value of the trust is. They have to give you, on deed of trust, they put the dollar amount in there. So let's say they paid $12,000 for the property, but they borrowed 10. Well, the deed of trust recorded after this would be for 10, but you still don't know how much more below $10,000 they paid, but they usually have to pay some. Do hereby grant, sell, do hereby bargain, sell, grant, and convey with general warranty of title and fee simple unto Young and his wife. So this is the bargain and sale deed. That's what it says there, bargain and sell. So this is the B&S deed. It's the second page of that same deed. I guess the cheapness in me, I didn't want to pay for all the rest of it, so I didn't print that out, but the signatures will be on the third page, which I didn't bother copying. But anyway, you have further description here, and there's actually meets and bounds in here. You can see they get the calls, so many holes. Yeah, this is north 73 degrees west, 20 holes. There's a pile of stones with hickory pointers in a corner to the north woodlot. The land hereby conveyed are the same conveyed into Orr and parties by deed from Frank and Margaret Alice Epps, his wife, bearing date 20th in 13Y 305. Is that the right reference? This is the derivation clause right here. 13Y 305. But we'll go back here since I don't remember. I know you can't. Although you have the access of the copy there. 13Y 305, 1952. So that's what the derivation. So that if you're looking at that deed, it tells you where they got it from. So you can, let's say these things are designed to go backwards. They're not designed to go forward, but you can go forward. But that's, so for the title examiners, this is to make their jobs easier for them. And they're going backwards. They just have to look at the derivation. They go to the next one, the next one, the next one, until they get back 60 years. Because title examiners are only required to research a deed back 60 years. Any liens that pre-existed that, they don't care. They're not warranting that to the bank. They're not making any guarantee one way or the other if it's prior to 60 years. Because the issue is whether is it still enforceable. Because that's one of the big things I talk to you about this. You're not learning all the things you need to know about real estate. You're learning how to follow deeds from one to the other. there may be a right of way on one of those deeds that was important to the present property owner. There may have been something they granted some water rights to some neighbor or something. That's in there that gave the neighbor access to the water on the property. So there could be various issues of easements and right of ways that the title examiner is concerned with that you want. Now, for me, it might indicate there's a cemetery on the property. I find that very interesting. But that again would create an easement. All right. Now, this is the tax records. This is from what year? Let's see, let me do this. This is 1959. So here's Robert and Barbara Young. And here's the property they own. I don't know why that doesn't add up 692 acres, but I noticed it doesn't. But that's what the assessment man has. This is how much the thing is worth, and that's the house there, value of buildings. In 1782, they started maintaining land tax records in Virginia. They still have land tax records today. But in 1820, they created a separate column for buildings. So starting in 1820, you can see what the tax man says the buildings are worth. But prior to 1820, it's all lumped together. There's no indication whether there's any buildings on the property or not. You have no way of telling whether there's buildings on it or not, other than for the value of the deed. But if you're looking for a building constructed from 1820 or later, you can start looking at the tax records and seeing when those numbers change. Now, back to this building number, there could be a house and a barn and several other outbuildings on the property that make up this one number. So you don't know how much the house is assessed for, because you don't know how many buildings make up the total number. That may be of importance to you if you're trying to research your property and figure out when your house was built. But again, look at these other numbers up here. That's a fairly high numbers. This was even higher, but again, what I always do if I'm working with something like that, I'll look at a known. All right. If I know a house that's standing in 1959, I'll go and see what that's assessed for. Then I'll compare that to the one I'm researching. So use a known against the unknown to get some idea as to maybe whether their house is a substantial house or not. Rather than having to convert back to 1959 dollars, just look at somebody else in the same time frame and say, okay, this house is from that time period. What is it worth? How is my house compared? How does this house I'm researching compare to that? But I want to point out to you that the land tax record actually has the deed book and page reference right there. That's something that exists today, just like it did on Mr. Glassman's record that I showed you from the assessment records. But that doesn't happen when you get back to the 1800s. They don't have this simple reference here to you. You just have to figure it out from looking at the indexes, whether it's the will or the deed index, to figure out what the source of the title was. When I did my 1860 maps, I just had the acreage and the person's name and a description where the property was, but I didn't have anything like this. This over here, see this? This is map number right here. About 19, I guess, must have been 1959, they had maps. I was gonna say they started in about 1960. That the county has map systems. I showed you some pictures from the map system that they have today. That map would help you locate where the property is. But when you get back prior to the mapping system, there's nothing to help you locate where that property is other than this description over here. All right, look at this one here. That property is not in Arlington, that the Zito zone, all right? It's on map 89 and 25, but they put their Arlington address, just like this has a Washington DC address, because that's what is in the tax bill. Now, when you go into the county assessment system today, they'll show you that the billing address is different from the property address. So it'll list both of them if you're working with property today. But this is from 1959. And they were printed sheets and I had them copied on the pages. This is a copy of the general index to deeds. And I got, they're alphabetical, so the pages are all the C's, they've got CO here, these are all COs. Down here at the bottom is Edward Coe from George Carter. I have a hard time reading these things. DNS 2F 433. Is that the right answer? And my last slide is right there. Now, this was a sale document from a chancery suit. When I did my chain of title, I don't have any chancery suits in there. But when all the codes were swapping the property back and forth around after Edward died in 1815, this is, I have the year 1830, this is from 1835. In that chancery suit, Rogers versus Simpson. I don't think Rogers or Simpson, any of the people on my chain of title. In the cause of you, Rogers, and others plaintiffs against John Simpson and other defendants, I shall offer for sale before the courthouse in Leesburg on the 16th day of December 1835 to the highest bidders of several tracts or parcels of land lying in Loudoun County in the neighborhood of Coe's Mill, which Edward Coe deceased devised to his sons, John W., Edward M., Meenan, and David I. Coe. Sale to commence about the middle of the day. Gives you lots of information there. Probably a lot more than you'd find in those deeds. So if you have a chancery suit in your chain, it is very helpful. In this case, I found this after I did the chain when I was doing some research. And so I included that just so you can see what kind of stuff you can find in chancery suits. This would actually be in the original paper from 1835. I don't know if y'all even have too many papers from 1835.
I was just about to ask, is that the Genius of Liberty or which publication is
I
that?
have no idea.
Okay,
Because what they do with the chancery suits, they're required to publish these things in the paper. And to prove to the court that they were published, they clip a piece of the paper out and stick it in the file. So this is actually in the file for this chancery suit. And the chancery suits can be accessed online. They're at the Library of Virginia. They've all been scanned and are online, so you can access those online from home. The Library of Virginia doesn't require you to have any special access to get on their website. And you could search chancery suits on the Library of Virginia's website. But they put these in here. So answering Anna's comment, I have no idea what newspaper it is because they don't bother to cut it out of the paper. Now, they probably will have a little piece of paper that this is attached to in there saying that it was published in a given paper on a given date. And then the actual copy of the paper is evidence that it was published. So you'll probably be able to figure out the name of the paper from the chancery suit, but I didn't bother to copy that either. Again, my cheapness, I said, I only want the paper, I don't want the other parts. So that's the last slide. So I'm now down to the questions and answers. If you have any, I should have told you earlier that you're welcome to interrupt me and ask me questions if you don't, but I asked you all some questions just to keep you involved, so. So if you have any questions about something that was confusing or something that I didn't cover in dealing with research and property.
What's online would vary from place to place, like what's available here in Loudoun County wouldn't necessarily be what's available in Alabama.
Well, when I started out, I said that I was talking about Virginia primarily. Back to this research in the chain of title and what they call public land states. And I think Alabama may be one of those. I know Ohio is, and most everything west of that is as well. But public lands were sold and they divided the property into sections and quarters and half sections or whatever. They actually in effect keep a chain of title in the records that when it's recorded, they should tell you in a book for that section and quarter who the owners are. So they don't have this deed book issue to go through in these public lands to the west. So it's much easier to track ownership on those type properties, public land states, than it is in Virginia and New Jersey and Maryland, whatever. So all the East Coast original states use the survey system where you have odd shaped properties and meets and bounds. You don't have those in the public land states. So you can have a survey, but it's all by sections and portions of sections. So it all is connected. The recording is connected to the property per se, as opposed to just recording it. Because one of the things I mentioned earlier was about the 5 deeds maybe, or five heirs and having 3 deeds. But yeah, when you have these heirs sell property, they'll just put in their deed that they're selling their interest in land they inherited from their parent. But they won't tell you how much that interest was or how much the property, how big the property was. So unless you can identify that, you know, what land that person inherited from their parent, the deed doesn't give you a good description at all. They're just very nebulous. Back to that earlier slide I had about the various descriptions, you know, that it was property on Limekill Road or was lot number 40 in the division. That's what deeds do. They transfer property. And sometimes they have a nice description of the land or meets and bounds survey, but other times they don't. And I know what I'm chain title sometime because I've had to do a lot of that in my mapping projects. I've not only done Loudoun, but I've done Fauquier, northern half of Prince William, Clark, and Warren County. Was that when you do all these large scale projects like I've done, you're running all the problems. If there's a problem out there, I've probably encountered it. And so when you do these multiple projects, you run into problems. So any potential mistake they had, you run into. And yeah, there's sometimes you look at a deed and you say, well, I know this has to be the deed for the property, but I can't prove it because it doesn't describe the property in a way that I can match to the tax record. But I couldn't find any other reference to it. And this is the only deed that seems to give this person that ownership.
So if I'm researching my farm, I go to the deed book first, right?
Normally, the first step you do is if you're researching your property, you start with your own tax record. You go with that on the assessment. And you make sure that the deed reference is back to your original deed. And then you would look at that. And back to that derivation clause, you're looking in your deed. Now, of course, you know who you bought it from,
Right.
But you would look at your deed and see what's the derivation clause, where did they get it from?
Right.
That's that, and then you work back from there. What the other example, again, that is most common is somebody comes in here from Ohio or Indiana, and they found out they had an ancestor here in 1820. And they want to figure out if they owned any land, and if so, where is it? Well, they have a much bigger problem than you do because you know where the property is. You've already started with that knowledge, but they don't know where it is. First, they don't know where their ancestor owned the land. So they'll go to the deed indexes like Pat has done, and they'll look for the person's name. Or they could use the actual courthouse indexes because they generally have an idea of what time they were moving through here. So they'll look for that person's name in the indexes, and if they find them in the indexes, then they can say, okay, there's a deed for them. But that doesn't tell them where that property is. All right. And the first deed that tells them where property, or excuse me, the first reference that tells them where property is the 1853 Yardley Taylor map. So if the person was here before 1853, they're not going to be on Yardley Taylor's map. So, okay, where's the property? And what I tell them is, well, that depends when they were here. I said, I can usually read a deed and tell generally where in the county they're talking about. But if it's close to 1860, they could use my maps to look for it. But if it's again 1802 that they were here in Loudoun County, if you can't tell from the description, you got two choices. You can go backward to the land grant, or you can go forward to the 1853 Yardley Taylor or 1860 Saffer maps and figure out where the property is. So you have to chain the property in the ownership from the time that you know they have it to some other time to figure out exactly where it is, because there's no real good sources. The tax list, as I say, just had the name, the acreage, and description. So it might, I tell people if it said on Goose Creek, are you all familiar with where Goose Creek is?
Slob.
Goose Creek enters Loudoun County at the Fauquier line, west of Middleburg, and exits Loudoun County at the Potomac River, east of Leesburg. So if it says their property is on Goose Creek, you're probably not going to be able to figure out, narrow it down too well. Now, there is something else in the tax records, and I haven't mentioned that, but distance from the courthouses is something else that's recorded in the tax books. So it's north 12 miles from the courthouse, then you know it's up towards Lovettsville or Taylorstown or something like that. You know it's not near Middleburg or Eastern Loudoun. So you can tell from those references the direction from the courthouse they were in. And in our case, we're fortunate that our courthouse has always been the same place. So when there's a reference from the courthouse, you know where to start from. In other counties, they move their courthouse around. So you got to make sure what year you're talking about in the tax records as to whether it's from Brentsville and Prince William County or Manassas or Haymarket as the courthouse moved around. So. Question online?
Yeah, we do. Is there separate tax information on mills? For example, Coe's Mill, that would include income and expenses, type of mill, customers, etc.
Let's see, the things I've used on mills, in the tax records, there's no separate listing in the real estate taxes. They would just list the property. So if you had the mill on 5 acres, it would list the 5 acres. The assessment would tell you there's something of value on the property besides just the 5 acres. But if it had 20 acres and a mill on it, it would be the same thing. It would list the person with 20 acres. So the tax records know. I've used the industrial census, which I think starts in 1850 and it goes at least up to 1870. I don't know if it goes beyond that or not, but the industrial census gives you good things from the decades of the census. The road cases quite often are something to look at if you're interested in a mill, because quite often roads were built in order to create access to mills. So you'll find references to mills in road cases, and quite often the guy who's built a new mill is petitioning the county to put a new road in. So those would be the suggestions as the road cases and the industrial census. Other questions? Okay.
Just kind of a follow up on it. You had mentioned William Nichols, which is part of my
People?
He's an ancestor, but yeah, my ancestor.
Well, I'm glad to know you had money in the family.
Had. But he had a land grant 1744, I believe. From Fairfax, Port of Fairfax. And then looking at the courthouse records, he bought quite a few properties that are recorded, after 1757. For a number of years. But like you were saying, looking at those deeds.
It doesn't pinpoint where it is. Yes.
It's like it's, from this large rock over here down, down the road to someone. You don't even mention, sometimes it'll mention somebody's property, but usually it's to the tall oak. And, you said you can, sometimes you can.
Well,
Recognize the location, but for a layman, looking at that, it makes no sense to figure out where that property is. So are you saying that, okay, keep following that, okay, who did he sell it to, and who did they sell it to, up until you get to Dorothy Taylor's name?
Well, as I was using that example from 1802, you either work backward to the land grant, because there's a land grant map that the county has prepared that locates where the land grants are. So if you can work the property back to the original land grant, then you can figure out where it is. If you can't, then you have to go at least 1853 forward to find Yardley Taylor. And in theory, back to what I was saying is, the system is designed to go backward. But the issue I usually say to researchers is you go to the closest point. So if you had 1850 deed, I would go to Yardley Taylor, because you only have to go 3 years or maybe 10 to my maps. But if it's closer to 7, because the land grants vary and when they're issued, that Oakland's one was 1727. And I think the one that I did in the first plat was like first chain was 1744. That the land grants are in the 1700s. So if your guy's at 1800 or earlier, you probably should go backward and you can figure out where it is easier.
Well, I have the land grant. I know the word is land grant.
But I mean, if he bought some additional land that you wanted to figure out where it was,
Right.
you would probably be better to chain it back to the original land grant that it was part of. You follow that?
Okay.
That you go from his deed back to the previous owners till you get to the land grant.
Okay. All right.
And then that way you pinpoint where it is.
Theoretically, the land grant might be 500 acres, but if he had gotten,
Yeah.
He may have got
He might have
parts
not,
of it.
yeah, no, not bought anywhere near all of it, no.
yeah,
I know one of the things I ran into in some research project I was doing was Piedmont Manor. I think Piedmont Manor is like 12,000 acres, something almost the size of Oakland's or bigger. And William Fairfax, who was an agent for Thomas Lord Fairfax, got this Piedmont Manor property. But he didn't sell any of it. He leased it out. This is where the German settlement is, north of Percival on up to the Potomac River. And he leased the land out to all these German farmers. Well, around the turn of the century, his heir, Ferdinando Fairfax, decided that he was going to sell it. He was going to sell off the land. He inherited it from William Fairfax. And he started selling it off. But he didn't want to have a lot of business selling all these 100-acre, 150-acre farms to all these Germans. So the speculator came in, James Lewis, and bought, I think it's James Lewis. I know Lewis is the last name. Anyway, he bought 10,000 acres of the property from Fairfax. And then Lewis started selling off acres. So it was kind of funny that these Germans had the money to buy their land, but Fairfax didn't want to have to fool with all of them. So he sold it as a large tract to somebody else. It was subject to the leases. These leases were still good. These Germans still had leases to the property they were on. But they ended up having to buy it from Lewis rather than buying it from Ferdinando Fairfax, because he just didn't want to fool with individual sales like that. So it's interesting that, but again, it was a decision around 1800 that Ferdinando Fairfax made to decide to sell the land. And that's true in the Lovettsville area, but that's also true in the Nearsville area. That the land over there was all part of a big land grant. And when Ferdinando Fairfax was the first one who was selling off lots, he inherited that as well. He was selling off all that land up through the Harpers Ferry Road area, 671. So all of that wasn't owned by deeds by local people until the 1800s. Prior to that, they were just leasing it from them. And again, that is very frustrating with the leases, because leases a lot of times weren't listed in the deed book. One of the things you run into in the land grant books, it'll have, let's say, Robert Carter, and it'll list like 20 names underneath of them. And it'll just have so many acres. What these people did when they leased the land, they required them to pay the property tax on the property. So it's listed under Carter in the deed book and in the land tax book. But it has the individual names of each leasee because he wasn't gonna pay the taxes. He said you have to pay the taxes on your lease. That's part of the lease agreement. So you can see that these people who are leasing this land are leasing land from Carter, but they don't all have leases in the deed book, even though they have official leases. So that you see the reference to the lease in the land tax records, but you don't see any reference in the deed book, because I don't know why. I don't know why he didn't record them, but a lot of times they didn't. And that was true throughout this time period when people were leasing in the 1700s, and quite often the deeds never got recorded, even though they typically had something called a free lives lease. I don't know if you've heard of those or not, but anyway, they would give a lease to a gentleman, and then he'd add his two sons' names on the list. And as long as any of those three people were alive, the lease was valid. Of course, they still had to pay the rent every year, but that was a valid lease for the lives of those three people. Yes,
The road changed, like, some stuff I'm looking at, I think I'm on the right property, but the name of the road has changed. Is there somewhere I can find when roads changed?
as I say, there is road cases there at the courthouse. They created a very nice index for those road cases. Lori Kimball was a volunteer down there doing that, paid person, I can't remember, but anyway, she did all the road cases, and so those are accessible out the courthouse, and so you can find some of that. There's not maps per se to identify where these things are. You'll have description in the road case telling you where it was from, but yeah, mapping wasn't something that they used way back then. I guess land wasn't of a major value, so they didn't bother to mapping. And as that thing that made those tax map references were from 1959. I have some of the early ones on like a blue piece of paper, and I got lines and showing where the parcel lines are. So you can get those, but prior to that, nothing like that exists. That's somewhat why I did the 1860, because there wasn't anything to identify where the things are. It took me about a year and a half to do the county, so. So it's very time consuming if you want to do a large area. And finding a single piece of land, even if you could plat it, and software to plat it, trying to locate where it is. I taught a class called Locating Property last time, and I used some examples in there showing where I could plat a piece of property and take the current land parcels and identify its location. And I used some examples that work, but not all work. But again, it relates to the oddity of the shape of the land. If it has a very odd shape, or if it follows a stream, if there were meanders of the stream that identify, it's much easier to identify where it is because the streams don't move that much. So you'd be able to find it. Like the roads move, but the streams don't. All right, well, thank you all for coming. What's this book right here? This is one of the deed books that Pat Duncan did.